Hello. Welcome to Crime and Court. This is my first episode of my newest series. I'm going to be doing a series of episodes. They're all going to be individual, so you don't have to watch them in any particular order or anything like that. So each week I'm going to just highlight on one individual who has been either wrongfully convicted, accused, executed for crimes that they did not commit. Because I really feel that this is a huge fail in our justice system. I don't think anyone who is innocent should serve one day behind bars, even if they're awaiting their trial. I think that there's a huge flaw in the way that we treat our inmates in in the United States and elsewhere too, but specifically I'm speaking for the U.S. I'm in Chicago area, and so I have that as my background. Anyway, so I really want to, this particular episode, let me show you the thumbnail real quick. So this episode is on Marcellus Williams, who is a man that is facing execution despite the fact that there is DNA that has been tested that supports his evidence. So he is 100% factually innocent, yet he's still sitting behind bars, and that's a problem. That's a huge, huge problem. And not just sitting behind bars, but he still could be executed at some point in time in the future. So, who is Marcellus Williams, the man facing execution in Missouri despite DNA evidence supporting innocence? DNA evidence not available at the time of Mr. Williams' trial proves his innocence, but has not been considered in court. So that is a picture of Marcellus Williams. I am using the Innocence Project website.org website as my source. This was an article posted by Alicia Mowell, August 15th, 2023, and just fair warning, I am going to be talking about the DP because he's on D row. So I'm going to actually skip, or maybe we'll just start at the top. Okay, so this article was actually updated on December 12th, 2023. All right, so in August, and there's been more that I'll fill you in on after this, but I want to read this first. So in August 2023, the Innocence Project, the Midwest Innocence Project, and Brian Cave Lighton Paisner sued Missouri Governor Mike Parson on behalf of Marcellus Williams for dissolving the Board of Inquiry investigating Mr. Williams' innocence claim and lifting the stay of Mr. Williams' execution. So let's break that down. All these individuals, Innocence Project, Midwest Innocence Project, and this, I'm sure this is a private attorney or something, sued Missouri Governor Mike Parson because there was a board of inquiry that was investigating this, was looking into whether they were going to let Marcellus Williams out. It was under a different governor, I believe, but then this governor came in and he dissolved the board. I don't know. Somebody dissolved this board. Oh, that's all I know. So, and then he lifted the stay of Mr. Williams' execution. And that was in June. So Governor Parson dissolved the board before it completed its investigation and provided him with a report and recommendation as required by law. So that was a requirement, not a suggestion. They should have completed their investigation and provided a report. All right, so the governor filed a motion to dismiss the lawsuit, but Cole County trial judge Cotton Walker denied the motion. Governor Parson then appealed Judge Walker's denial to the Missouri Supreme Court, which stayed Judge Walker's decision. If St. Louis County Attorney Wesley Bell doesn't intervene, the Missouri Supreme Court could dismiss Mr. Williams' lawsuit against them or against the state, I should say, not against the Supreme Court, but against the state. The Supreme Court could dismiss that lawsuit and set an execution date for Mr. Williams anytime. So let that sink in. He's already been on death row for a while now, and he's already had a sentence date, and it's been stayed multiple times at this point now. So Mr. Williams, who's 53 now, has spent 24 years of his life, so almost half of his life he spent in prison. That's awful. And not just in prison, he's on D row for an unaliving that DNA evidence proves someone else committed at this time. So we know he didn't do it, and we know he's been sitting in prison for 24 years for a crime he hasn't committed, but let's just keep him in there longer. So in 2017, then Governor Eric Greitens stayed his execution minutes before it was scheduled to take place as a result of Governor Parsons' decision to lift the stay. So the first governor, the original governor in 2017, said, I'm going to stay his execution minutes before his life was supposed to be extinguished. So think about that for a second, how awful that would be, knowing you're in prison for a crime that you didn't commit. You spent almost half of your life in prison for it, and you know there's DNA that exonerates you, but you're going to go to get executed anyways. And you literally go to sleep the night before knowing that the next day is the last day of your life. But then, oh, surprise, it's not. Because we're going to put a stay on your execution. Well, anyways, he's probably very relieved that he doesn't have to be executed that day. But then Governor Parson comes along and he decides to lift that stay. So now Mr. Williams risks being executed for a crime that he did not commit. And here is the crime. In 1998, Felicia Gale, a former St. Louis Post-Dispatch reporter in St. Louis, was stabbed to her end 16 times in her home. 2 years later, Mr. Williams was convicted of first-degree unaliving, robbery, and burglary of Ms. Gale. His conviction primarily relied upon the inconsistent testimonies of two incentivized witnesses with no concrete physical evidence linking him to the crime scene. One of the witnesses, Henry Cole, only reached out to police 10 months after the crime when all leads had run cold and saw an opportunity to secure a deal for himself on his own cases. He had his own charges that he was facing for other crimes and took it as an opportunity to reduce his sentencing. He told investigators that Mr. Williams had admitted to the crime while they were both in prison, and he would testify to that if they helped him in return. And we just talked about that in Wisconsin versus Zachariah Anderson, because a former cellmate of the defendant, they only were cellmates for a couple weeks while he was awaiting his trial, and the cellmate told him that he had a dream, he was dreaming about killing him, and then he told him the next day, yeah, I was dreaming about it, I was screaming, die, 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 and all this stuff, and it's ridiculous. And it was so dramatic and unbelievable coming from a witness who is benefiting from being on the stand by potentially reducing their current charges. So, anyways. In 2016, testing of DNA samples taken from the unaliving weapon excluded Mr. Williams as a contributor, providing that he did not commit the crime and contradicting the testimony used to convict him. Though no execution date has been set as of now, They haven't rescheduled it. One could be scheduled as early at any time. That's not really a thing. I think they just mean at any time. Or they were going to say as early as, and then they just put any time. All right. And Mr. Williams' life remains at risk for a crime that he did not commit. So, all right. So here are several reasons, or several things that we know about the case that is going to help give you just some background information on this. So number one, Mr. Williams has been excluded as the source of the DNA found on the unaliving weapon. On August 11th, 1998, Dr. Daniel Pekas came home from work around 8 p.m. to find his wife Gail unalive at the bottom of the stairs. She had been stabbed 16 times and one of their kitchen knives was protruding from her neck. Graphic warning, guys, sorry. In 2016, post-conviction DNA testing conducted on the handle of that knife detected the presence of a male DNA, and that DNA was excluded, or Mr. Williams was excluded from that DNA, I should say. All right, so number two, no court has reviewed the exculpatory DNA evidence. In 2017, then Missouri Governor Eric Greitens stayed Mr. Williams' execution based on the DNA results from the knife handle. However, no court has been willing to hear this evidence, which has been reviewed and analyzed by 3 renowned DNA experts, who have all concluded that Mr. Williams is not the source of the DNA on the knife handle. So it's been confirmed by 3 separate sources that he did not provide the DNA that was on that knife handle. So number 3, the prosecution's case against Mr. Williams was based entirely on the unreliable testimony of 2 incentivized witnesses. This is such a problem, and this should never happen. All right, so the case against Mr. Williams relied heavily on testimony from 2 people. Mr. Cole, a prison informant, and Mr. Williams' ex-girlfriend, Laura Asaro, later referred to as Ms. Asaro. Okay. However, the credibility of both of their testimonies has significant grounds for skepticism, and here's why. Mr. Cole, known for his dishonesty by his family members, his own family members, tell you he's not honest, had a potential motive to fabricate or exaggerate his claim that Mr. Williams confessed to him while they were both incarcerated. Mr. Cole initially refused to participate as a witness in Ms. Gale's case, so this case against Mr. Williams, he refused, until he was promised payment and then made it clear in the 2001 deposition that he would not have come forward if it hadn't been for the $5,000 that he was given by the prosecutors. The prosecutor's office paid Mr. Cole, a prison informant, $5,000 to testify against Mr. Williams. That should make us all irate. What were they? It also makes me realize that they didn't have a case against, and they knew they didn't have a case against Mr. Williams, because why else would you be paying your witnesses to say what you want them to say? Anyways, moving on. This makes me angry. All right, so notably, several details in his testimony were strikingly similar to the information that had been published in newspapers about the unaliving, suggesting that he had been fed this information directly or indirectly. So he either took it upon himself to find the information out, and it's very easy to, this is why people were talking about Richard Allen, like, eating his discovery or whatever, but this is why you do it, because other people will take your discovery and use it against you in prison and be like, oh yeah, they'll read it and then act like they know everything about the case and try to get time off of their prison sentence. Anyway, so notably, several details in his testimony were strikingly. Oh, I said that, sorry. Prior to the deposition, Mr. Cole had pled guilty in a 1996 armed robbery of a bank and was sentenced to 4 years of probation with 10 years of prison suspended. Although he violated parole 6 times, the court never imposed this suspended prison sentence on him. But you're making deal. He violated his parole 6 times. And he was in prison for this other crime. Yet, let's believe him over this other guy. It's not just let's believe him, it's let's believe him and put him on as a witness for our case. It's crazy to me that they would do stuff like this, but hey, people like to win at all costs. Sometimes prosecutors are like that too. Alright, so Ms. Asaro also had a history of deception and had faced solicitation charges when police initially approached her about the case in November 1999. She had worked with the police before and had testified against Mr. Williams in a previous trial. So she's basically a police informant too, because she worked with the police before and she's testified against Mr. Williams now twice, or, previously. So she even lied under oath in her recorded deposition regarding her arrest history. At some stage, police had considered charging her as an accomplice in the crime. Miss Asaro also mentioned to her neighbor that she was receiving money for her testimony against Mr. Williams. That it should never happen. You should never be giving money for testimony unless they're like an expert witness and they're being paid for their consultation services and to review things. Then you pay them by the hour. Further, adding to the doubt, the narratives from Mr. Cole and Ms. Asaro were significantly different and didn't match the crime scene evidence. For example, Ms. Asaro testified that Mr. Williams had scratch marks on him, but there was no foreign DNA present under Ms. Gale's fingernails. The only evidence connecting Mr. Williams to Ms. Gale's unaliving was the testimony of Mr. Cole and Ms. Asaro. According to the National Registry of Exonerations, incentivized witness testimony has contributed to 14% of DP cases that later led to DNA exoneration. That's sickening. And that's just DP cases. So how many cases have incentivized witness testimony? How many cases has that contributed to for just, life in prisons or, a sentence rather than the DP? All right, so the two incentivized witnesses in this case were motivated by the reward money and favorable treatment in their own criminal cases. And that's usually what happens is they get time taken off their sentence. Number 4, no scientific or eyewitness evidence or motive connects Mr. Williams to the unaliving. Even though the unaliving occurred in the middle of the day and neighbors were out and about, no one saw Mr. Williams anywhere near Ms. Gale's house. Police found shoe prints that were left in red fluid DNA at the scene and concluded that they did not belong to Mr. Williams. So you've got the unaliving weapon, the knife, doesn't have his DNA. And then you've got these shoe prints that aren't his. You've got people like his ex-girlfriend testifying against him. And then you don't have courts looking at the exculpatory evidence. So this is what's wrong with our system regarding these innocent people. All right, so what was the other thing about the shoe? I forgot. They also collected and tested biological evidence from the scene and determined that none of his biological evidence belonged to Mr. Williams. So his his DNA was not even present at the scene. So he had not, like, he wasn't even there. He had nothing to do with it. Number 5. In 2017, then Governor Creighton stayed Mr. Williams' execution because of the powerful exculpatory DNA evidence. All right, so in August 2017, then Governor of Missouri Eric Greitens intervened just hours before Mr. Williams' scheduled execution, signing an executive order postponing the date. This was not the first time Mr. Williams' execution had been put on hold. Like I said, can you imagine that? Like, going to bed at night thinking, like, this is the last night I'm on this earth, and everyone's going to be thinking I did this crime, and I didn't. And, well, this life sucks, man. I mean, what else are you thinking at that point? Like, life is not fair. Governor Greitens assembled a board. This is the board of inquiry that was supposed to investigate the case and review all the evidence that had been presented at the trial. The board was also tasked with reviewing newly found DNA evidence and any other pertinent evidence to which the jury may not have access. So, anything that came out since the trial, like this DNA evidence, is fair game for them to look at. The order granted the board the authority to demand testimony and information and required it to keep its proceedings and all collected information confidential, which also could mean there's some prosecutorial misconduct or some kind of misconduct on law enforcement's end, and you're kind of investigating that, because why else keep it keep all of it confidential. The executive order clarified that the execution would be postponed until the governor had decided whether Mr. Williams should be granted mercy based on the board's findings. However, it is unclear if any report has ever been issued. Mr. Williams' legal team never received a report, and Governor Parson dissolved the board without giving any indication that he had received a recommendation, and if so, what it was. Mr. Williams' case is riddled with unreliable, incentivized testimonies and a complete absence of physical evidence linking him to the crime scene. The lack of consideration by any court of the exculpatory DNA evidence, which indisputably excluded Mr. Williams as a contributor, calls into question the validity of his conviction. Despite the evidence pointing to his innocence, Mr. Williams remains on D row more than 2 decades after his initial arrest. With the weight of the new evidence and the unreliability of the witnesses who testified against Mr. Williams, his conviction must be reevaluated to ensure that justice is truly served. His legal team, comprised of dedicated professionals from the Innocence Project, the Midwest Innocence Project, and Brian Cave, and attorneys Larry Comp and Kent Gibson, continues to fight to stop his execution and for his exoneration, hoping that justice will finally prevail. All right, so next up, this is the most recent update that we have on Marcellus Williams' case. So evidence here's the title. St. Louis prosecuting attorney Wesley Bell files motion to overturn Marcellus Williams' wrongful death conviction. Evidence of Mr. Williams' innocence could be heard in court. So this was written January 29th, 2024 by Innocence Project and Midwest Project staff, and it is urgent. So, for more than 20 years, Marcellus Williams has lived under a DP sentence for a crime he did not commit. He has always asserted his innocence, which is supported by physical evidence. Mr. Williams was not the source of the footprints found at the scene, nor the unknown hairs that were left behind. In 2016, DNA testing proved 2016 he's been sitting in prison. So, nearly 8 years later? He's still sitting in prison, though there's DNA that proves he didn't do it. That was on the unaliving weapon. The DNA belongs to an unknown male, yet no court has ever considered all of the evidence together. Mr. Williams, therefore, has sat on D row for decades as punishment for a crime that someone else committed. In 2017, however, on the eve of Mr. Williams' scheduled execution, Governor Eric Greitens provided some hope for justice when he appointed a board of inquiry to review all of his evidence and make a recommendation as to whether he should use his clemency powers to overturn Mr. Williams' conviction to reduce his sentence. That hope was dashed last June when Governor Mike Parson improperly dissolved the board before it could finish its work, and Attorney General Andrew Bailey moved to set an execution date. So they're just like, nah, we don't care. We're just going to keep going forward with this execution, regardless of the fact that it was stayed in the past. The possibility that the state of Missouri could execute an innocent man did not matter to them. That is not justice. But hope for justice has now been restored. We are grateful to St. Louis County Prosecutor Wesley Bell. I keep wanting to call him Ball. Wesley Bell and his office for reviewing the evidence and filing a motion asking that the St. Louis County Circuit Court overturn Mr. Williams' conviction, providing a long-awaited avenue for all of the evidence of Mr. Williams' innocence to finally be heard. We encourage other prosecutors to follow this example and act to correct injustices that have occurred in their jurisdiction as required by their ethical duties. Like, this is almost never heard of, where a prosecutor looks at a case and says, oh, wait, we made a mistake. There's a mistake here. This person's not guilty. That, like, never happens. So this is pretty rare. We are confident that any full and fair process will lead to the inevitable conclusion that Mr. Williams is innocent and his conviction must be overturned. Mr. Williams is presented by Innocence Project and then Midwest Project. It gives you a little more information about them if you're curious, and his attorneys. So you can actually help. So I already signed it. I'm showing you that I signed it here. Let's see if I refresh, if it'll go back to what it was. So this is actually the petition. I know he's on like the home page, and you could search his name on the website too. But there is a petition, which is not loading right now. I don't know why this is taking so long, but you can click on this link here and it'll take you to a page where you can, it is not loading, a page where you can sign a petition just in support of having him exonerated and released from prison. And it shows up on this side of the screen right here, but it's just not showing up right now. It's being really slow. It'll come up. So just be aware that this is out there. This is a way you can help. You can also share it on social media. That would be great. So this is saying that the state could schedule an execution date as early as January 3rd. Well, they haven't scheduled a date yet, but they still could at any point, which is why it's important to come to this page and here it is. Here it is. You just want to fill out your name, zip, and email, and submit, and it's that easy. And you can sign very quickly. I'll put the link below in the description of this video so you can find it easily too. All right, so my last article I wanted to get to, it has a lot more information than more details. So I just wanted to give you, it's still like the same update as to Attorney Wesley Bell putting in the motion to vacate his sentence. So, as you can see, this is from the dpinformationcenter.org. So it's the dpinfo.org webpage. And I used this in the first episode of the series too, which is the Innocence Project, where I kind of talked about the Innocence Project, and then innocent people on D row that were likely, or what I should say rather, is people on D row that were executed that were most likely innocent, and DNA pretty much proves that now. So each case is a little different, so I don't want to say they're all like that, but it's interesting. All right, so after Attorney General's request for execution date, St. Louis County prosecutor files motion to vacate Marcellus Williams' D sentence, and this was posted February 1st. So this is the latest update that I could find on him. So on January 26th, 2024, St. Louis County prosecuting attorney Wesley Bell filed a motion in the St. Louis County Circuit Court asking the court to vacate Marcellus Williams' D sentence. Mr. Williams was sentenced to have his life ended in 2001 for the 1998 ending of a local newspaper reporter. So I wanted to bring that up, and I forgot in the earlier that the victim in this case was a local newspaper reporter. Don't you think that line of her career, like, it's kind of dangerous if she was reporting on something dangerous, and it might have been she got too close, she got too much information, she talked to the wrong person. I don't know, but it's very possible that it had something to do with her position. And as soon as I saw her job title, that's what I thought. Anyways, so local newspaper reporter Felicia Gale, he has been sentenced to have his life taken because of her life ending in 1998. But he has maintained his innocence throughout his entire incarceration. No physical evidence has tied Mr. Williams to the crime, and the trial court judge refused to allow DNA testing on some of the evidence collected from the crime scene. In 2015, Mr. Williams was eventually given permission for DNA testing of the unaliving weapon, which revealed a male DNA profile inconsistent with that of Mr. Williams. Following the rules of a 2021 Missouri law that grants prosecutors the authority to intervene in cases when there is, quote, information that the convicted person may be innocent, end quote. So exculpatory evidence. Mr. Bell filed his motion to vacate Mr. Williams' sentence. In his motion, Mr. Bell noted that, quote, the never before considered evidence, when paired with the relative paucity of other credible evidence supporting guilt, as well as additional considerations of ineffective assistance of counsel and racial discrimination in jury selection, casts inexorable doubt on Mr. Williams' conviction and sentence. So all of those things, there were many, many things at play that could have led to just not getting a fair trial and violating his rights. So Mr. Bell has asked the court to schedule a hearing to consider the DNA evidence and other evidential flaws in the state's case against Mr. Williams. Mr. Bell's office continues combing through the police investigation of Ms. Gale's unaliving to determine whether the investigation was, quote, intentionally or recklessly deficient, and is looking into an alternate perpetrator, end quote. So they are looking. Mr. Bell's office is looking for, they're doing their own investigation into it to find out where it leads, basically. The motion also notes that Mr. Bell believes it it is his job to ask the court to, quote, correct this manifest injustice by seeking a hearing on the newfound evidence and the integrity of Mr. Williams' conviction, end quote. This motion was filed shortly after the Missouri Attorney General Andrew Bailey asked the Missouri Supreme Court to set an execution date for Mr. Williams. Attorneys for Mr. Williams, working for the Innocence Project, said that they are confident that any full and fair process will head to the inevitable conclusion that Mr. Williams is innocent and his conviction must be overturned. St. Louis police suspected Ms. Gale's unaliving was a robbery gone wrong, and the crime scene details matched those of a crime that occurred just weeks earlier. Law enforcement identified a prime suspect, but no arrests were made until a monetary reward was offered. Thereafter, a jailhouse informant, Henry Cole, told police a story about how Marcellus Williams, a former cellmate of his, confessed to unaliving Ms. Gale. It's that cellmate. Oh yeah, I used to bunk with him for a couple of days, and now I know everything about him. Police later secured another informant, Mr. Williams' former girlfriend, Laura Asaro, who told police that Mr. Williams ended Ms. Gale. Both Mr. Cole and Miss Asaro were facing unrelated criminal charges and stood to benefit from testifying for the state. The prosecution relied heavily on testimony from both Mr. Cole and Miss Asaro, which shifted throughout the course of their questioning. So how did the jury not see through that? I don't know. But it's easy to convict when you've got the state with all the power and all the resources to pick apart your client. If you're the defense, going up against such a powerful organization, the state, everyone combined, works together, and they, the medical examiner has to report back to the officer that brought them the body and whatnot, so they all work together. They're all related in their views of how things should be. Sorry. All right. So, what do I want to say? The prosecution relied heavily on testimony from both Mr. Cole and Mrs. Arrow, which shifted throughout their questioning. Their testimony also contradicted the physical evidence collected from the crime scene. Ms. Asaro claimed that Mr. Williams had scratches on his face the day following the unaliving, but no foreign DNA was discovered under Ms. Gale's fingernails. Additionally, the shoe prints at the crime scene, which were in the red DNA stuff, they were a different size than Mr. Williams' feet, and the fingerprints that were lifted were unusable and never given to the defense to analyze before they were destroyed. So now evidence is getting destroyed. Despite the DNA testing in 2015, the court refused to allow Mr. Williams to enter the newly discovered evidence during post-conviction proceedings and scheduled an execution of August 2017. The Midwest Innocence Project, which represents Mr. Williams, asked then-Governor Eric Greitens to halt the execution. Governor Greitens issued an executive order staying Mr. Williams' execution and impaneling a 5-member board of former judges to assess the credibility and weight of all the evidence. Per Missouri law, the board is required to produce a final report for the governor as to whether or not Mr. Williams should be executed or his sentence of D be commuted. In June 2023, however, Governor Mike Parson dissolved the Board of Inquiry before the report was ever released or provided. Attorneys for Mr. Williams immediately challenged the governor's attempt to disband the board. In his motion to the court, Mr. Bell alleges that Mr. Williams' trial attorneys provided ineffective assistance of counsel by failing to call witnesses to impeach the credibility of Mr. Cole and Miss Asaro. As we saw in Wisconsin versus Zachariah Anderson, I have an episode of I have 2 episodes on witness credibility where there's some witnesses on the stand, and we go through the cellmate that does testify against the defendant, Zachariah, and he just seems very not credible to me. But what I was going to say was the whole questioning on cross-examination was really more about impeaching them and getting the jury to understand that they were on this, that he was on the stand, the cellmate informant was on the stand only to benefit for his own case. So they really hit that home in their questioning, because it's important to impeach them and let the jury know that. It didn't work for Zachariah because he still got convicted, but that was other reasons. All right, so Ms. Williams' conviction was also the result of prosecutorial misconduct, as prosecutors illegally struck several black jurors from service. This is awful too, and this has been seen in other cases. This is not unique. There's, I don't know what state it is, I can't remember, but Curtis Flowers, might be Arkansas or Georgia or something, I don't remember. But Curtis Flowers was charged like 5 or 6 times for the same murder, or the same, unaliving. I'm not supposed to say that word. And the prosecutor was extremely headstrong in trying to get Curtis Flowers prosecuted for these crimes. I think it was a double homicide. And there was so much evidence that was, exculpatory, but it never came out in trial. And the prosecutor always was striking the black jurors, and the defendant was black. So that's not his peers. You need to have your peers. I'm sorry, but you got to have your peers. People who are most like you. All right, so during jury selection, the prosecution said that they did not reject a black juror because of his race, but rather because he, quote, looked very similar to Mr. Williams. So friggin' what? The prosecutor also claimed that he struck the juror because he worked for the postal system and postal employees tend to be very liberal, yet he did not strike a white postal employee. The prosecution team responsible for handling Mr. Williams' conviction has been involved in at least 2 other DP convictions that have been reversed by the Missouri Supreme Court. So that is really important to note, that this prosecution team that was going after Mr. Williams has had DP convictions overturned by the Missouri Supreme Court on multiple occasions at this point. So hopefully we get an overturned conviction here for Marcellus Williams sometime soon. Hopefully the Supreme Court will take his case on and look at it, and it's in the hands right now of the governor, I think, right? Or no, I think it goes back to circuit court, because he's asking, I don't know. I think it goes back to circuit court, but it's this attorney's asking. I don't know now. I'm confusing myself. Anyways, that is at least up until now. Now we're kind of current on what is going on with Marcellus. Oh, you know what? I want to end on this. Glad I came back to this and remembered. So this is a poem that Marcellus Williams wrote. All right. So we'll end it on this note. This is called The Superman Syndrome by Marcellus Williams. Never wrote a poem about my father. Although near, he wasn't around, so why bother? Papa was a true Rolling Stone. Maybe the Vietnam War cut too deeply and distorted his view of his own. So forgiving is my heart. I have forgotten much, but clearly remember a beating as our first embrace, our first touch. Some may diagnose it dissociative experience due to me not viewing this bonding as traumatic. Even the use of bonding to many will be enigmatic. Now behold, he is my father, the first superhero type. Never knew at the time he would just be a stereotype. Still my heart keeps to forgiveness because I can see past the world's flesh. No tears were shed growing up due to being born with no regrets. Firstborn, I am here adding to his malfunction. I can only remember a yellow dump truck, a bomb pop, and a croquet set without instructions. But when I say he's a master carpenter, I feel a sense of his worth. Then I realize I was never taught such. Abandonment attempts to surface along with shame and hurt. These are just illusions, deceptions, and whispers. Believe me, devils are real, and I can hear the hissing, but I ignore them, no doubt, when they spew their fiction. Alcohol addiction, a player in his game. How can one be cured from a disease that eases pain? Writing a poem about my father brought up feelings I never knew I had. Growing up, I never thought of him, so I felt nothing, and even now it's hard to consider it sad. Now come on and tell me that you understand how kryptonite can be one's children, so he forego the part of being a man. The truth is that I know that many can relate. Lost so the rectification of my soul, so I refuse bitterness and I reject hate. Therefore he still deserves respect and kindness as he is a parent, a divinely prescribed order shunned by many, but for my heart so necessary and apparent. It was by Marcellus Williams, who has a lot of time to write beautiful poetry because he's sitting in prison for a crime he didn't commit. For 24 years he's served. So, if this outrages you as much as it does to me, please go over to the innocenceproject.org website. I will put a link in the comments below to where you can go to sign the petition. They have over 41,000 signatures at this point, and 41,232, and I did mine. So please go over there, sign the petition, write to the governor of Missouri, write to the DA of Missouri, get these, help in getting these charges dropped if this outrages you, as it does me. You can also write to Marcellus Williams. Prisoners, they feel very alone and very very rejected by the rest of the world. And to have, especially someone who has done nothing wrong, it is important that we let them know that they're not forgotten. So that is why I am doing the show. I really believe firmly in this. It breaks my heart, and I'm like almost in tears right now just talking about it, because I don't like the idea of someone sitting in prison who didn't do a crime and they think that the world has just abandoned them. So on that note, please go sign the petition. And thank you so much for watching. Share this video, comment, like, do all the YouTube-y things. I appreciate you being here, and I will catch you on the next one. Thank you so much. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeandcourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.